Hello, friends. My name is Dan. And oh wow, do I have a treat for you. The phone call you're about to hear was recorded in, I believe it was June 2016. And I'm speaking with a senior Crown prosecutor named Ken Madsen. What we're discussing here is the criminal assault charge that I laid against Sergeant Alex Yellowvats after he criminally assaulted me in February 2016. What we're discussing in this call is the charge approval standard that Crown Counsel uses to assess whether or not to charge someone who's had a criminal charge laid against them. Now, I've pulled this out of my extensive collection from way back in my archives, because I thought it would be good to post this now because it's kind of relevant to what's going on with me right now and Crown Counsel. So I wasn't planning on publishing this now, but I think now's a good time to throw it out there. Now, Ken likes to abuse the process. Ken is about to prove to you that Ken uses a double standard. And Ken is about to prove to you that the laws do not apply to everyone. Now, Ken sent me a letter previous to this phone call saying that he had dropped the criminal assault charge against Sergeant Alex Yellowvats because it didn't meet the charge approval standard. And at the end of the letter, he said if I had any questions, I could feel free to contact him. So I did. Because what I wanted to know was how it was possible for me to be charged with the criminal offense of assault when there was no evidence. What I specifically wanted to know was, how did that meet the charge approval standard? And that's that bogus assault allegation that Ron Kirkwood falsely arrested me and falsely imprisoned me for. You remember the charge I was prosecuted for without any evidence? The one where I had to represent myself in a criminal trial? And I actually won because it was just that easy. And the case was so poorly brought forward without any evidence. So what does Ken think about accountability, transparency, and what does Ken think about when citizens lay criminal charges against his highly awarded sergeants in his police departments? And what does Ken think about Crown Counsel prosecuting people without any evidence, and how that charge even got approved according to their charge approval standard process? Well, here it is. Yeah, it was odd because I filled out a private information at the criminal registry at the law courts in Victoria. And they said that they set a date for 6 weeks for me to show up to court. And when I went to court 6 weeks on that date, it was supposed to be to set a date for a process hearing. And that never happened.
Yes, that is correct.
So is that normal when a private citizen does a private information and the police, does it normally get investigated by the police?
I've reviewed what the police provided in the course of their investigation.
Right, but I haven't provided the police with everything, though.
As I said, all I can review is what the police... The Crown doesn't investigate. All we do is we assess the investigation that has been done against our charge assessment standard.
Okay, because I'm still waiting for my process hearing.
Okay, the process hearing is not going to occur because the proceedings... I reviewed the evidence. It did not meet our charge assessment standard, so the prosecution has been terminated.
Okay, fair enough. So if I get what you're saying correctly, if a citizen has a video of them being assaulted by a police officer and the police officer admits on the video that he's assaulted the person, and the person has photo evidence of the assault, of an injury, that doesn't meet the standard?
Well, that is not what you can take from it. What I did was I assessed all the evidence that was provided, including what your statement was and what I saw on the video, as well as the statements that I indicate to you from Mr. Grenier and Mr. Connolly, and I determined that it would not meet the evidentiary standard of our charge assessment policy.
Okay, and can you think of any cases that the Crown is handling right now where they're dealing with a charge of assault, but there's no evidence of an assault?
The Crown applies its charge assessment standard to all cases that come in. So if there's a case the Crown is prosecuting that is before the courts, it's because it has been on the review of the material provided by the investigating agency. It meets the charge assessment standard. And
if that charge, specifically there's one I'm talking about, where there's no evidence of an assault, I'm specifically talking about a charge that the Crown has accepted, where there's an allegation, a charge of assault, but there's no evidence.
Right. Well, as I said, the Crown applies in every case that we receive an investigative report from the police.
Yep.
Our charge assessment standard.
Right.
We review it based upon what we view to be the admissible evidence, the likely weight of that evidence,
yep,
as well as any defenses that seem apparent from it that are non-speculative.
Yep.
And if we view that based on all those factors, there's a substantial likelihood of conviction, it would proceed to prosecution. So at this time, I'm not aware of any cases that we are prosecuting that do not meet that standard.
You are, in fact. So what I'm going to do is I'm going to make this very public through YouTube and the video that the Crown has accepted an assault charge where there's no evidence of assault on a private citizen. However, in another case where there's been a private information put forward, where there's video evidence, photographic evidence, and even the police admitting on the video that there was an assault, the Crown said that it doesn't meet their standard of whatever. How do you think the public's going to feel about that, sir?
Well, I think an informed public will be able to arrive at a decision about that.
So, if I hear you correctly, you're okay with me filing a private information with the criminal registry, and you're okay with there not being a process hearing, and you're okay with staying a charge that does have video evidence, photographic evidence, even the police officer who committed the assault admits it on video, and you're staying that doesn't meet your whatever. But there is a charge that is being put forward, that is being prosecuted by the Crown, that's a separate charge, a separate incident, where there is no evidence in any way, shape, or form, and there's now a trial for that.
No, that's not what I'm saying, sir. What I'm saying is the material you provided to the investigating officer,
yeah,
and quite honestly, you can characterize it however you want, but currently you are mischaracterizing it.
I would disagree with that.
Our charge assessment standard.
Yeah.
I'm not going to get into hypotheticals with you about some case that you're talking to for which you've not identified it, beyond to say that the charge assessment standard has undoubtedly been applied to that case, and unlike this case, it's been found to meet it.
Okay, so I just find it very odd, because in Canada, people have rights, correct?
They do indeed.
Okay, so one of the rights of the people in Canada is you can't be prosecuted arbitrarily, correct?
In Canada, you will, if you're in British Columbia, you won't be prosecuted unless the police have investigated it, the Crown have reviewed it, and it has met our charge assessment standard on the evidentiary basis of a substantial likelihood of conviction.
So I'm trying to figure out how there is a assault charge that the Crown has moved forward to a trial and a trial date where there's no evidence of the assault.
Well, at this point, if it meets our policy standard, it'll proceed, and if the assault did not occur to a beyond reasonable doubt standard, the court will determine that.
Okay, I'm just trying to figure out how that charge got approved where there's no evidence, but this charge where there's ample evidence, and I haven't even had my process hearing, and I haven't even put all my evidence forward, that doesn't meet? Because it sounds to me like maybe, just maybe, the Victoria Crown Council is just simply in bed with the Vic PD.
Well, sir, that is not the case. We exercise an independent discretion. That's the reason that there's a two-stage process. The police investigate, the Crown review the evidence, and make a determination if charges will proceed.
Yeah.
So that concern that you express there is not well-founded.
As I said, I'm going to be making this very public. I'm going to compare the two cases, and the public will decide. The public will be the judge. So we're going to have a lot of public information here about an assault charge that went through where there's no evidence, and then another assault charge involving a police officer where there's ample evidence, photographs, video. The police officer even admits it on the video, and that doesn't meet your standards. So I think the public trust is going to be very, very low with our Victoria Crown Council here.
Well, indeed, if that's the result after the public has a full understanding of the things, then that would be unfortunate, but such is the situation. That having been said, I've reviewed the case very carefully. Your characterizations of it are not completely accurate, and that's the reason an objective point of view was brought to it, as opposed to a subjective one. It's one of the reasons underlying the policy.
One more question here. How can you say that my interpretation is inaccurate when A, you weren't there, and B, you're supposed to be, objectively, you've got a statement you got 35 pages of a statement from someone who wasn't even at the scene. I never saw them. I'm telling you right now, if they were there, they were more than 100 feet away. And that should be clear on the video. That should be obvious. And that's going to be obvious when all this comes to light in the public light.
All right. Thank you.
Yeah. So just one more question, Ken?
Yep.
Have you ever been named a co-defendant when someone sues the Ministry of Justice?
Oh, that is not something that I'm prepared to share with you, sir.
Okay, well that does tell me a lot right there. And compare the two cases where there's been an allegation of assault. You've got one Crown Council doing one thing and another Crown Council doing another thing, and they're apparently both supposed to be on the same standard level.
All right. Did you have any other questions, sir?
No. I think I'm good, sir.
Good. All right. Take care. Bye-bye.
Take care. So what's your opinion on Ken Madsen? Well, that's my opinion. Feel free to debate it in the comments section below. And thanks for watching.